Okay, we'll now proceed with the division on Amendment 117. This will be a 1-minute division and members should cast their votes now. And the vote is now closed. Point of order, Richard Leonard.
Thank you, Presiding Officer. My platform wouldn't connect. If it had, I would have voted yes.
Thank you, Mr Leonard. I'll make sure that is recorded. Point of order, Alex Cole-Hamilton.
Try calling Alex Cole-Hamilton.
Point of order, Alex Cole-Hamilton.
You can reassure Claire that she has voted successfully.
I can reassure Ms Baker that your vote has been counted, yeah. Point of order, Alex Cole-Hamilton.
Sorry, Presiding Officer, my app wouldn't connect, and apparently not my audio either, but I would have voted no.
Thank you. I will make sure that is recorded. So the result of the vote on amendment number 117 in the name of Paul O'Kane is yes 49, no 71. There were no abstentions. Therefore, the amendment is not agreed. I call amendment 118 in the name of Paul O'Kane, already debated with amendment 117. Paul O'Kane to move or not move?
Not moved.
That is not moved. I call amendment 1 in the name of the Minister, already debated with amendment 117. Minister to move formally.
Move formally.
The question is that amendment 1 be agreed to. Are we all agreed? We are agreed. I call amendment 119 in the name of Paul O'Kane, already debated with amendment 117. Paul O'Kane to move or not move?
Not moved.
That is not moved. We move to Group 3, review of regulatory performance, a request from the Scottish Parliament. I call Amendment 2 in the name of the Minister, in a group on its own. Minister to move and speak to Amendment 2. Minister.
Thank you, Presiding Officer. Amendment 2 makes clear that any request made by the Scottish Parliament to the Lord President to review the performance of a Category 1 or a Category 2 regulator can only be made following a resolution of the Scottish Parliament in plenary. So I move Amendment 2 in my name.
Nobody else has asked to speak, Minister. Is there anything you wish to add by way of wind-up?
Just to confirm that this will not affect the ability of the Consumer Panel or Consumers Scotland to request a review either. Thank
you, Minister. The question is that Amendment 2 be agreed to. Are we all agreed?
Yes.
Parliament is agreed. We move to Group 4, minor and technical amendments. I call Amendment 3 in the name of the Minister, grouped with amendments as shown in the groupings. I call Minister to move Amendment 3 and speak to other amendments in the group. Minister.
Thank you, Presiding Officer. Amendments 10, 61, 98, 99, 100, 102, 114 and 115 are minor and technical and correct or update cross-references. Amendments 3, 17, 18, 19, 20, 21, 24, 25, 26, 103, 104, 105 and 106 correct errors and tidy up the bill. In relation to Amendment 4, Section 37 of the bill applies the new provisions which relate to regulators accredited under the bill to regulators approved under Section 26 of the 1990 Act, such as allowing a review and updating of the regulatory scheme at the direction of the Lord President. To date, the only regulator approved under Section 26 is the Association of Commercial Attorneys. Section 32A was inserted at Stage 2, allowing a review and updating of the regulatory scheme to take place at the regulator's own initiative, as well as the direction of the Lord President. Section 35A, inserted at Stage 2, introduced a role for the Lord President in securing replacement regulatory arrangements for authorised providers where their accredited regulator has ceased operating. Amendment 4 amends Section 37 of the bill to apply both the new Sections 32A and 35A to the Association of Commercial Attorneys. Section 76 of the bill expands on the information that must be included in the SLCC's annual report and also requires the SLCC to consult the Lord President, the Consumer Panel and each regulator. Amendment 27 is in response to concerns raised by the SLCC and makes it clear that this requirement to consult is triggered at an early stage in the process before the report is prepared. Regarding Amendment 63, Section 47(1) of the Solicitors Scotland Act 1980, as amended at Stage 2, provides that an authorised legal business must not, without the written permission from the Law Society, employ a solicitor who has been struck off the roll or suspended from practice. The sanction for acting in contravention of this requirement is set out in Section 47(4). As amended by the bill, any authorised legal business acting in contravention will have its authorisation to provide legal services automatically withdrawn for a period determined by the Scottish Solicitors Discipline Tribunal or the court in the case of an appeals against the refusal to be granted permission by the Law Society. Amendment 63 instead provides for a more flexible approach to imposing sanctions, allowing the tribunal or the court in the case of an appeal to impose conditions or restrictions on the authorisation of an authorised legal business to provide legal services. Amendment 101 ensures that there is a right of appeal against decisions to restore a solicitor's practising certificate subject to conditions in cases where the solicitor has complied with requirements relating to the refunding of excessive fees charged to a client. Amendments 108, 109 and 112 move a provision that was inserted into Section 16 of the 1980 Act at Stage 2 to correct its place at Section 34 of the Act. Amendments 110 and 111 are minor technical amendments which insert titles into sections of the 1980 Act. This was noted by the Law Society of Scotland and the Scottish Solicitors Discipline Tribunal. I therefore ask members to support the amendments in my name, and I move Amendment 3.
Thank you, Minister. No other colleague has asked to speak. Is there anything you wish to add by way of a wind-up?
No, thank you, Presiding Officer.
The question is that Amendment 3 be agreed to. Are we all agreed? Yes. Parliament is agreed. I call Amendment 4 in the name of the Minister, already debated with Amendment 3. Minister to move formally.
Move formally.
Thank you. The question is Amendment 4 be agreed to. Are we all agreed? Yes. That is agreed. I call Amendment 120 in the name of Paul O'Kane, already debated with Amendment 117. Paul O'Kane to move or not move?
Not moved.
That is not moved. I call Amendment 121 in the name of Paul O'Kane, already debated with Amendment 117. Paul O'Kane to move or not move?
Not moved.
That is not moved. I call Amendment 122 in the name of Paul O'Kane, already debated with Amendment 117. Paul O'Kane to move or not move?
Not moved.
Thank you. I call Amendment 123 in the name of Paul O'Kane, already debated with Amendment 117. Paul O'Kane to move or not move?
Moved.
That is moved. The question is that Amendment 123 be agreed to. Are we all agreed? Yes. That is agreed. I call Amendment 124 in the name of Paul O'Kane, already debated with Amendment 117. Paul O'Kane to move or not move?
Not moved.
That is not moved. I call Amendment 125 in the name of Paul O'Kane, already debated with Amendment 117. Paul O'Kane to move or not move?
Not moved.
That is not moved. I call Amendment 126 in the name of Paul O'Kane, already debated with Amendment 117. Paul O'Kane to move or not move?
Moved.
The question is that Amendment 127 be agreed to. Are we all agreed? Apparently, Amendment 126, sorry. For clarity, the question is that Amendment 126 be agreed to. Are we all agreed? Yes. Excellent. Group 5, cost recovery, I call Amendment 127 in the name of Paul O'Kane, grouped with Amendments 128, 136 and 91. Call Paul O'Kane to move Amendment 127 and speak to all amendments in the group. Mr O'Kane.
Thank you very much, Presiding Officer. Just in case colleagues were missing the sound of my voice, I move Amendment 127 in my name, and I am very grateful to the Minister for her indication that she will not be moving her Amendment 91 and instead is minded to support my amendments 127, 128 and 136. These amendments deal with the issue of cost recovery by regulators when collecting a financial penalty that has been imposed upon a business. Whilst the penalty is payable to the Scottish ministers, it is the regulators that collect it, which will incur costs, and it does not seem reasonable or fair for the rest of the profession, the rest of the legal profession, and by extension the consumers who are consuming legal products, that they have to cover the costs of that process. These amendments would allow regulators to recover reasonable costs, as well as build in flexibility to discontinue or resume collection where it becomes unreasonable or infeasible to collect the financial penalty. And I believe that by collaborating on these amendments, we have been able to bring together a sense that will bring more natural justice into the process, both for lawyers and indeed for consumers.
Okay, I call the Minister to speak to Amendment 91 and other amendments in the group. Minister.
Thank you, Presiding Officer. After careful consideration of amendments numbers 127, 128 and 136 in Paul O'Kane's name, I am content to support these provisions and ask members to support Mr O'Kane's amendments in this group, and I will not move Amendment 91.
Thank you. Paul O'Kane to wind up. Press to withdraw Amendment 127. Mr O'Kane.
Nothing further, Presiding Officer.
The question is that Amendment 127 be agreed. Are we all agreed? Parliament is agreed. The question is that Amendment 128 be agreed. Are we all... Pardon? I call Amendment 128 in the name of Paul O'Kane, already debated with Amendment 127. Paul O'Kane to move or not move?
Moved.
And therefore we move to the question is that Amendment 128 be agreed. Are we all agreed? Yes. That is agreed. It takes us on to Group 5, complaints process. I call Amendment 5 in the name of the Minister, group with amendments as shown in the groupings. Minister to move Amendment 5 and speak to the other amendments in the group.
Thank you, Presiding Officer. I'll firstly turn to my own amendments in this grouping. Section 54(7) of the bill repeals Section 12 of the Legal Profession and Legal Aid Scotland Act 2007. Section 12 specifies how the Scottish Legal Complaints Commission, known as the SLCC, must notify the complainer and the practitioner of a decision to uphold or not uphold a service complaint. The SLCC and I agree that this is too restrictive, so the amendments provide for minor and technical changes to add additional flexibility. Therefore, Amendments 9, 83, 84, 85 and 88 amend paragraph 26 of the Schedule 3 of the bill to remove the express requirement that notice under Sections 3, 8, 16, 17 and 24 of the 2007 Act must be in writing. Amendment 5 repeals Section 45 of the 2007 Act, which relates to the giving of notices, and 89 is a consequential amendment to that. New Section 28 enables the complainer and the practitioners to whom the complaint relates to apply to the SLCC for a review of its decisions as listed in the provision. An amendment passed at Stage 2 now allows the SLCC to discontinue the investigation of a complaint if the practitioner accepts a settlement proposed by the SLCC, but the complainer does not. Amendment 7 ensures that this decision by the SLCC is a reviewable decision, therefore securing a right of review and enhancing transparency and accountability in the complaints process. Section 61 of the bill inserts new Section 17A into the 2007 Act, giving the SLCC the power to request practitioners' details in connection with complaints. Amendments 12 and 13 expand the power in Section 17A to cover the investigation and reporting of handling complaints. The charges also enable the power to be used by the SLCC when they initiate a conduct or a regulatory complaint. Amendments 86 and 87 amend Section 17 of the Legal Services Act 2007 by adding a reference to new Section 2A following the Stage 2 amendments which added complaints initiated by the SLCC and handling complaints to the list of sections mentioned in 2007 Act. This is to rectify a SLCC concern, which was the omission of handling complaints from the powers in Sections 17 and 17A. Amendment 14 amends Section 66 of the bill, which in turn amends paragraph 1 of Schedule 3 of the Legal Profession and Legal Aid Scotland Act 2007, which lists what rules for the practice and procedure of the SLC must include. The effect of Amendment 14 is that the rules must include provision to require complaints that are frivolous, vexatious and totally without merit to be considered as ineligible, which would mean that the SLCC need not take any further action other than to give notice to the fact to the complainer, the practitioner or any other person required under these rules. Amendment 6 and consequential Amendment 8 removes the ability to review the decision to categorise a complaint as a conduct complaint or as a regulatory complaint. We agree with the SLC's view that these decisions should not be open to review, particularly given the introduction of hybrid complaints, where complaints can now be categorised as both types, conduct and regulatory. Amendments 15 and 16 make small changes to Section 66 of the bill, which amends Schedule 3 of the 2007 Act. The changes mean that the SLCC practice and procedure rules relating to the recategorisation of services complaints includes regulatory complaints. Turning now to Mr O'Kane's amendment, I cannot support amendment number 135 as I consider it would weaken the SLCC's authority to set standards in complaints handling. The minimum standard setting was introduced in response to calls for a more independent regulation of legal services from stakeholders representing the consumer interests. Consumer bodies support the strengthening of the independent oversight by the SLCC in terms of setting minimum standards for complaints handling. And as you will remember from the committee heard from evidence from Rosemary Agnew, the Scottish Public Services Ombudsman, that this is the best practice. Giving the Lord President a direct role in determining whether guidance which sets minimum standards is to be complied with or not in this way may be viewed as a step away from the consumer-focused approach, and I do not think that allowing a veto to the setting of minimum standards potentially prior to the consultation by the SLCC is in the consumer's interest. The current procedure for setting and issuing minimum standards within the bill is aimed at providing greater quality assurance and continuous improvements in complaints handling. The process is currently drafted, is open and transparent, and involves the SLCC carrying out a consultation to seek the views of those persons or their representatives who will be affected prior to issuing any guidance that sets minimum standards. The SLCC must consult the Lord President, the regulators, practitioners and any other appropriate persons on the initial proposals. The SLCC must then consult the regulators and other appropriate persons again on any subsequent drafts and must take into account any representations made and further to that to publish a document summarising the consultation undertaken, the responses, any changes made to guidance as a result, giving its reasons for including the minimum standards. As the Lord President is a statutory consultee, they will have an opportunity to express their views on the proposed minimum standards at that initial stage. The intention is that the regulators and the Lord President have an opportunity to raise any concerns or challenge any proposed minimum standards through the initial statutory consultation process. As an iterative process, ultimately, given the role of the Lord President in approving a regulatory scheme which must contain practice rules about the making and the handling of complaints, as well as the revisions to it, the Lord President could withhold consent to any subsequent practice rule change to reflect those standards if they retain concerns with the proposals. This would then require the SLCC to address any concerns raised by the Lord President or abandon the proposal. The SLCC considered that adding even more stages to the processes adds to the cost of the system and potential delay in addressing emerging consumer protection issues. Moving on to Mr O'Kane's other amendments, and I'm pleased to be able to work with Mr O'Kane on Amendments 11 and 19 in this group, which provide relevant professional organisations the power, where they are considering initiating a complaint against a practitioner or an authorised legal business, to give notice to the practitioner or the practitioner's firm or the authorised legal business, requiring the production and delivery of the documents specified in the notice relating to the complaint. The amendments will allow all lawyers working for the Crown Office, the Procurator Fiscal Service, to be exempt from any requirement placed on them to provide information to prevent interference with the prosecution functions and independence. And I am grateful to Mr O'Kane for taking on board my concerns, and I am content to support Amendments 11 and 90. I'm also pleased to be able to work with Mr O'Kane on his Amendments 22 and 23 in this group, which provide expressly that the Law Society of Scotland, who have discretionary powers to disclose information where it is in the public interest to do so, are not subject to the restriction in Section 52(1) of the 2007 Act, and that the SLCC, who have the discretionary powers to disclose information where it is in the public interest to do so, are not subject to the restriction of Section 41(1) of the 2000 Act. I'm therefore content to support amendments number 22 and 23. I ask members to support amendments 5, 6, 7, 8, 9, 12, 13, 14, 15, 16, 83, 84, 85, 86, 87, 88, 89 in my name, and I urge you to please support 11, 22, 23 and 90 in the name of Paul O'Kane. However, I ask you not to support Amendment 135 in Mr O'Kane's name, and I move Amendment 5.
Thank you, Minister. Just to clarify, we are dealing at the moment with Group 6, and I call Paul O'Kane to speak to Amendment 11 and other amendments in the group. Mr O'Kane.
Thank you very much, and I'll begin by thanking the Minister for her cooperation and collaboration, indeed, on Amendments 11 and 90 and on 22 and 23 in my name within this grouping. Amendments 11 and 90 would provide relevant professional organisations the power, where they are considering initiating a complaint against a practitioner or an authorised legal business, to give notice to the practitioner or the practitioner's firm or the authorised legal business, requiring the production and delivery of the documents specified in the notice relating to the complaint. The amendments will allow lawyers working for the Crown Office and the Procurator Fiscal Service to be exempt from any requirement placed on them to provide information to prevent interference with their prosecutorial functions and independence. Amendments 22 and 23 indeed would provide expressly to the Law Society to have the discretionary powers to disclose information where it is in the public interest to do so. And I believe that all of those amendments are extremely important in terms of ensuring the swift resolution and advancement of complaints, but also ensuring that we have strong transparency in terms of when complaints are taken forward. I believe that they are good news for transparency and indeed for proactive regulation. Additionally, in this group, as we have heard, is my Amendment 135, which would permit relevant professional organisations to appeal SLCC directions on minimum standards to the Lord President for his determination. So I would begin by saying that I wholeheartedly agree with the Minister that the SLCC's ability to direct minimum standards will provide for a strengthening of the consumer voice and hopefully will lead to improved practices within the complaints process. And I note that that is a position which I think has been widely accepted by the profession. But I do think it is reasonable to consider that the SLCC, like any person or any organisation, is not infallible. And there may be guidance that they issue which doesn't account for certain circumstances. It may be impractical guidance, or indeed it may simply be wrong. And even with the processes which include consultation with affected stakeholders, wrong or impractical conclusions could still be drawn. Indeed, evidence could simply be ignored. I think in those instances it does seem fair to give the profession a mechanism to voice those concerns to a third party. And in this case, it would be the Lord President for his final consideration, where he may, of course, uphold the direction in part or in full or indeed vary it. Indeed, I think the Lord President has indicated agreement with this position in principle in a letter he sent to the Equalities, Human Rights and Civil Justice Committee ahead of Stage 3. And he stated that the Senior Judiciary's view was that the bill should be amended so that the Lord President is given a power to approve the SLCC guidance, which sets minimum standards before these are imposed on a regulatory body. The Lord President approves the practice and disciplinary rules of the Law Society and the Faculty of Advocates. If minimum standards from the SLCC are to be included in rules which the Lord President approves, and the Lord President does not agree with these rule changes because the SLCC minimum standards are not workable or appropriate, the Senior Judiciary thought it would be unlikely that the Lord President would approve those rules. So I would note that without this mechanism proposed, it is, in particularly egregious examples, the only avenue that would be available to relevant organisations would be to seek judicial review. And I think that in itself would be significantly more costly, more time-consuming than any potential costs or delays that would result from this final ability to refer guidance to the Lord President for his final direction. So it seems that the Minister and I are at odds, certainly, on that point. But it does seem to me that this amendment that I have raised is a reasonable safeguard, and it is why I intend to press it today. Thank you.
Thank you, Mr O'Kane. And I call Maggie Chapman.
Presiding Officer, can I begin by thanking the Minister and her officials for the constructive and helpful conversations we've had at various stages of this bill. Turning to this group, we support most of the amendments in this group, but I'm not convinced by the argument put forward by the Minister regarding Amendment 14. This amendment would reinstate the frivolous, vexatious and totally without merit wording that we removed at an earlier stage. I do understand the intention. Indeed, we discussed this at length at Stage 2, to ensure that complaints that are clearly intended to waste time can be dealt with swiftly. I agree that this is important. But the SLCC does not support this amendment, arguing that we should grasp the opportunity this bill provides to remove legalistic, offensive or archaic jargon, replacing it with more consumer-friendly language. The terms in the amendment aren't just archaic or inaccessible, they have derogatory meanings in ordinary contemporary English, and so will almost inevitably have negative impact. Just because there is a body of case law attached to the terms is not reason enough to keep them. They will likely have to be changed sometime, so surely sooner rather than later is better. The Commission has said that the streamlined triage processes outlined in the bill would allow complaints requiring further investigation to proceed swiftly to either resolution or to the relevant regulator, and those that don't require investigation can be dealt with quickly without delay too. The SLCC is the expert in handling complaints, including communicating to consumers when they cannot be taken forward. If they say this wording is unhelpful, we should perhaps respect their expertise, and I'd be grateful to the Minister if, in her winding up, she could say why we should not in this case. Thank you, Presiding Officer.
Thank you. I call on the Minister to wind up and formally.
Thank you, Presiding Officer. Just in relation to Mr O'Kane's Amendment 135, I appreciate that this is a Law Society amendment. But as all of us have known during the passage of this bill, there has to be a balance for the consumers and the legal profession. And my view is that Amendment 135 will weaken the SLCC's authority to set standards in the complaints handling. And we know that consumer bodies support the strengthening of independent oversight by the SLCC. And if I can just address... Yes.
Paul O'Kane.
I'm very grateful to the Minister for taking the intervention, and I do recognise what she's outlining. However, does she also recognise that letter that came from the Lord President and his view in terms of being a final port of recourse before the potential of having to go to judicial review? Does she share my concerns that judicial review can be costly and can slow things up even more?
Minister.
No, we don't share your view. We have to, I think, agree to disagree here. I think there has been a lot of concessions for the legal profession throughout this bill, and I think we really have to look after the consumer bodies, and that this is why we will be opposing Amendment 135. If I could just just comment on amendment number 14 that Maggie Chapman has raised. She will be aware that this was one that was raised at stage 2. So we have engaged with the SLC on the approaches of this to try and find a compromise to move forward with this, and a flexible approach to allow the SLCC to investigate a complaint more quickly while retaining the requirement to reject complaints without any merit. So that's why we've put this one forward. Thank you, President.
Thank you. The question is that Amendment 5 be agreed to. Are we all agreed? Parliament is agreed. I call Amendment 129 in the name of Paul O'Kane, already debated with Amendment 116. Paul O'Kane to move or not move?
Not moved.
That is not moved. I call Amendments 6, 7, 8, 9 and 10, all in the name of the Minister and all previously debated. I invite the Minister to move Amendments 6 to 10 en bloc. Minister?
Moved en bloc.
Does any member object to a single question being put on Amendments 6 to 10? No. The question is that Amendments 6 to 10 be agreed. Are we all agreed? Yes. Parliament is agreed. Call Amendment 11 in the name of Paul O'Kane, already debated with Amendment 5. Paul O'Kane to move or not move?
Moved.
Question is that Amendment 11 be agreed to. Are we all agreed? Yes. Parliament is agreed. I call Amendment 12 in the name of the Minister, already debated with Amendment 5. Minister to move formally.
Move formally, Presiding Officer.
Question is that Amendment 12 be agreed to. Are we all agreed? Yes. Parliament is agreed. I call Amendment 13 in the name of the Minister, already debated with Amendment 5. Minister to move formally.
Move formally.
Thank you. The question is that Amendment 13 be agreed to. Are we all agreed? Yes. We are agreed. We move to Group 7, registered of unregulated legal services providers. Call Amendment 130 in the name of Tess White. Group with Amendments 131, 132, 133, 134 and 142. Tess White to move Amendment 130 and speak to all amendments in the group. Ms White.
Thank you, Presiding Officer. I move Amendment 130 in my name. I'd like to thank the Minister for her constructive engagement on Section 65 following Stage 2 of the Bill. Amendments 130, 131, 132, 133, 134 and 142 in my name allow the Scottish Government to lay regulations which would give specific organisations the mechanism to request that an unregulated provider of legal services is formally registered. At Stage 2, I lodged amendments from the Law Society which sought to change the voluntary register for unregulated providers of legal services in Section 65 so that it becomes mandatory. The Law Society's position was that a voluntary register, which requires payment of levies and fees and which subjects a service provider to a statutory complaint scheme, is, and I quote, unlikely to attract a meaningful uptake, and I agree. The Equalities, Human Rights and Civil Justice Committee's Stage 1 report called on the Scottish Government to strengthen the provision and consider creating a mandatory register. Stakeholders such as the Competition and Markets Authority have made similar calls. However, the Scottish Legal Complaints Commission raised concerns about how the amendments at Stage 2 would work in practice. My view remains that it is in the public interest to have a mandatory scheme. Consumers currently have no recourse to raise complaints about an unregulated provider. And I'm pleased at Stage 3 to have worked with the Scottish Government to find a way to strengthen Section 65 that satisfies stakeholders. The Law Society states in its Stage 3 briefing that my amendments significantly toughen up the provisions in this bill and lay the foundations to begin to address the issues in the unregulated sector. The SLCC states that it is a proportionate and risk-based approach, and I'm grateful to both the Law Society and the SLCC for their expertise and insights during this process, which has led to a positive outcome for consumers. And I urge colleagues to support these changes.
Thank you, Ms White. And I call the Minister.
Thank you, Presiding Officer. I'd like to take this moment to thank Tess White for her engagement and her contribution to the bill through Amendments 130 to 134 and 142. These amendments significantly enhance the clarity and structure of the provisions relating to the registration of unregulated legal service providers under the legal profession and legal Aid Scotland Act 2007. The amendments collectively strengthen and enhance transparency and ensure that the process for registration to the voluntary register for unregulated legal providers is both accountable and consultative. I will ask members to support the amendments in Tess White's name. Thank you.
Thank you. I now call on Tess White to wind up. Press to withdraw Amendment 130.
Nothing further to add, Presiding Officer, other than to thank the Minister and those involved for their input and engagement on this package of amendments.
Thank you. The question is that Amendment 130 be agreed to. Are we all agreed? Parliament is agreed. I call Amendments 131, 132, 133 and 134, all in the name of Tess White, all previously debated with Amendment 130. I invite Tess White to move Amendments 131 to 134 en bloc. Ms White.
Moved en bloc, Presiding Officer.
Thank you. Does any member object to a single question being put on Amendments 131 to 134? No. The question is therefore that Amendments 131 to 134 are all agreed. Are we all agreed? Yes. Thank you. Call Amendments 14, 15, 16, 17, 18, 19, 20 and 21, all in the name of the Minister and all previously debated. I invite the Minister to move Amendments 14 to 21 en bloc. Minister.
Moved en bloc.
Does any member object to a single question be put on Amendments 14 to 21? Yes. Ms Chapman, can I just clarify, it's simply Amendment 14? 14. The question is that Amendment 14 be agreed to. Are we all agreed? Parliament is not agreed. There will be a division and members should cast their votes now. The vote is now closed. Point of order, Joe Fitzpatrick.
I should connect and I would have voted yes.
Thank you, Mr Fitzpatrick. I'll make sure that is recorded. Point of order, Shona Robertson.
Voted yes.
Thank you, Ms Robertson. I'll make sure that is recorded. Point of order, Pam Gosal.
Connect. Presiding Officer, I would have voted yes.
Thank you, Ms Gosal. I'll make sure that is recorded. Point of order, Colin Beattie.
Yes.
Thank you, Mr Beattie. I will make sure that vote is recorded. And the result of the vote on Amendment 14 in the name of the Minister is yes 104, no 8. There were no abstentions. The amendment is therefore agreed. I just ask if any member objects to a single question being put on Amendments 15 to 21. No, in which case the question is that Amendments 15 to 21 are all agreed. Are we agreed? Yes. Parliament is agreed. I call Amendment 135 in the name of Paul O'Kane, already debated with Amendment 5. Paul O'Kane, to move or not move?
Moved.
The question is that Amendment 135 be agreed to. Are we all agreed?
Yes.
Parliament is not agreed. There will be a division and members should cast their votes now. The vote is now closed. And the result of the vote on amendment number 135 in the name of Paul O'Kane is yes 48, no 67. There were no abstentions. The amendment is therefore not agreed. I call amendment 22 in the name of Paul O'Kane, already debated with amendment 5. Paul O'Kane to move or not move? The question is that amendment 22 be agreed to. Are we all agreed? Yes. Parliament is agreed. I call amendment 23 in the name of Paul O'Kane, already debated with amendment 5. Paul O'Kane to move or not move?
Moved.
Question is that amendment 23 be agreed to. Are we all agreed? Yes. Parliament is agreed. I call amendments 24, 25, 26 and 27, all in the name of the Minister and all previously debated with amendment 3. I invite the Minister to move amendments 24 to 27 en bloc. Minister.
Moved en bloc, Presiding Officer.
Does any member object to a single question being put on amendments 24 to 27? No. The question is that amendments 24 to 27 be agreed. Are we all agreed? Yes. Parliament is agreed. I call amendment 136 in the name of Paul O'Kane, already debated with amendment 127. Paul O'Kane to move or not move?
Moved.
The question is that amendment 136 be agreed to. Are we all agreed? Yes. Parliament is agreed. We move to Group 8, Licensed Legal Services Providers, changes to the 2018 Act. I call amendment 28 in the name of the Minister, group with amendments 29, 30, 65, 66 and 67. Minister to move Amendment 28 and speak to all the amendments in the group. Minister.
Thank you, Presiding Officer. Amendment 28 makes it clear that different licence fees can be charged to different types of applicants for different types of or categories of a licence to reflect the fact that there are now many types of business models entering the legal services market, such as those providing incidental financial services. The amendment allows for the changing of bespoke fees to be permissible under the Legal Services Scotland Act 2010. Allowing the charging of such fees would be part of the regulatory scheme rules. They would need to be approved by Scottish ministers with the agreement of the Lord President, thus ensuring a check on the fee charging. An example of a licence that would only apply to certain businesses would be the Incidental Financial Business Licence. Amendment 29 repeals Section 49 of the Legal Services Scotland Act 2010. This removes the requirement that for business entities to be eligible to be a licensed provider, they must be at least 10% owned by solicitors or members of other regulated professionals. This simplifies the regulatory framework and potentially broadens the pool of eligible professionals, which will encourage more diverse ownership structures within the legal profession and foster innovation and competition while maintaining high standards of professional conduct. Under the 2010 Act, an approved regulator must be satisfied that all non-solicitor investors are fit to have an interest in a licensed provider, for example, in terms of their financial position and character. Section 64(4) of the 2010 Act provides that if a non-solicitor investor is a body, then the regulator must be satisfied as to its fitness of both the body and any person having ownership or control of that body. Amendment 30 relaxes this requirement so that if it only applies in respect of persons who have significant control or ownership as determined by the approved regulator, taking a more proportionate approach. The bill repeals Section 1 of the 2010 Act, removing the duty on regulators to comply with specified regulatory objectives in the 2010 Act in favour of the new regulatory objectives introduced by Part 1 of the bill. Amendment 65 similarly repeals the obligation on legal service providers to have regard to the regulatory objectives under the 2010 Act. Instead, these providers will need to adhere to the professional principles set out in Part 1 of the bill. This change will reduce the regulatory burden on legal service providers, making compliance more straightforward while maintaining high professional standards. Sections 77 and 78 of the 2010 Act are therefore not needed, and Section 77 requires approved regulators to act compatibly with regulatory objectives in the 2010 Act, and Section 78 requires approved regulators to issue a policy statement in relation to Section 77. Amendment 66 repeals these sections, and Amendments 65 and 67 make related consequential changes. I move Amendment 28. Thank you.
Thank you, Minister. No other member has asked to speak. I invite the Minister to add any comments you wish to in the wind-up.
No, thank you, Presiding Officer.
Thank you. Question is that Amendment 28 be agreed to. Are we all agreed? Yes. Parliament is agreed. I call Amendment 29 in the name of the Minister. Already debated with Amendment 28. Minister, to move formally.
Move formally, Presiding Officer.
Question is that Amendment 29 be agreed to. Are we all agreed? Yes. Parliament is agreed. I call Amendment 30 in the name of the Minister. Already debated with Amendment 28. Minister, to move formally.
Move formally, Presiding Officer.
The question is that Amendment 30 be agreed to. Are we all agreed? We are all agreed. Group 9, safeguarding. I call Amendment 31 in the name of the Minister. Group with amendments as shown in the groupings. Minister, to move Amendment 31 and speak to all amendments in the group. Minister.
Thank you, Presiding Officer. Where a solicitor or authorised legal business is unable to continue to operate, the safeguarding provisions inserted into the Solicitors Scotland Act 1980 by the Bill enable the Law Society to take on any client account of that former solicitor or authorised legal business. This includes the ability to make a direction requiring the former authorised legal business to take any specified action. My Amendment 34 allows for an authorised legal business to appeal such a direction to the court. While this is a protective process which can be put in place urgently, it is important that these matters can be tested by the court and that the court's decision is final. I am aware that the Law Society has raised some concerns about delay, but we think that could be catered for by the courts in urgent circumstances. The Lord President also raised whether there should be an appeal following stage 2. The safeguarding provisions in new Section 46A of the Solicitors Scotland Act 1980 apply in relation to an authorised legal business that is comprised of a sole solicitor. And Amendment 45 provides the definition for that term. Amendments 37 and 38 together make it clear that those safeguarding provisions also apply where the sole solicitor has ceased to practice for any reason. Similar but not identical requirements to satisfy the Law Society apply in those circumstances under Section 46 of the 1980 Act at present. Amendment 42 follows amendments at stage 2 and sets out duties that an authorised legal business must comply with within 21 days of its sole solicitor ceasing to practice. Though the requirements are different, they are not onerous. The vesting in the Law Society as provided for in the Bill will not, as the Law Society has said, apply unless a solicitor is disqualified, as in the provision at present. The main point is to give the Law Society the ability to make a direction. The amendment also enables a solicitor or authorised legal business to whom a direction is given to appeal against it to the Court of Session, as mentioned previously. Amendments 31 to 33, 35, 36, 39, 40 to 44, 47, 46, 48 to 58, 60, 62 and 64 are minor technical amendments to update the drafting style and correct minor errors such as cross-references. I ask members to support my amendments in this group, and I move Amendment 31. Thank you.
Thank you, Minister. I call Tess White.
Thank you, Presiding Officer. The Scottish Conservatives are broadly supportive of the amendments in this grouping, but as the Minister says, the Law Society has flagged two amendments in particular which they believe are problematic, and these are Amendments 34 and 42. As the Minister says, these amendments would create a new right for a business to lodge an appeal to the court when the Law Society directs them as part of its remit to intervene directly in the public interest. The Law Society has raised serious concerns about this approach, which they believe weakens public protections by delaying the ability to take necessary action to safeguard clients' assets. They give the example of a conveyancing transaction to demonstrate the need to intervene urgently to protect client interests. So I'd just like to ask the Minister Again, has the Scottish Government taken into consideration the unintended consequences of these provisions which could negatively impact the consumer?
Thank you. And I call Paul O'Kane.
Thank you very much. And I would like to also press the Minister around those concerns expressed by the Law Society and others regarding Amendments 34, 30 and 42 in this grouping. Throughout the bill process, the Government and members across Parliament have been trying to strike the right balance between effective and efficient regulation and the interests of consumers and their protections. I am concerned that introducing the appeal mechanism in Amendment 34, on top of existing and other court actions, in situations where a regulator has intervened in a failed firm and given directions to safeguard client interests, could delay the ability to take forward actions at speed. Indeed, we have already heard from Tess White and the example of where a client files to complete an urgent conveyancing transaction, but it may be impossible to complete that transaction. That is a very serious issue. It's a circumstance I'm sure many of us are familiar with in terms of being in a chain and needing speed when you're involved in conveyancing. So I wonder if the Minister has weighed those potential consequences on consumers, and why does she feel that that additional right of appeal is so critical? On Amendment 38, I would ask what consideration the Minister has given to the unintended consequences from the catch-all mechanism she created for triggering safeguard mechanisms in Section 46A of the 1980 Act, given that there are reasons for cessation of practice, such as retirement, which don't necessitate safeguarding mechanisms to be triggered. Similarly, on Amendment 42, I worry about the practicality of requiring all sole practitioners who cease practising to prepare and submit interim accounts and notify all clients within 21 days, when often a date for cessation is not determined until well after the fact. And regarding the appeal rights and directions from the regulator contained in this amendment, I would refer members to the arguments I outlined earlier in this speech in relation to Amendment 34. So, as it stands, I'm concerned that these amendments, both individually and together, are unnecessary. They're impractical steps, I think, to the process, and they are contrary to the consumer interest. And so I and this side of the chamber are minded to oppose these amendments. Thank you.
Minister, to wind up.
Thank you, Presiding Officer. When I agreed to support Tess White's amendment at stage 2 in respect of safeguarding the interests of clients, I did advise I would revisit the provisions at stage 3 to ensure they work fully with the wider legislation and make any adjustment to reflect the wider policy intention. Given the implications for a practitioner and following consideration of a query made by the senior judiciary, as I say, I've lodged Amendments 34 and 42, which would provide an appeal mechanism on the 14-day appeal timescale for the appeal to be final. This would allow for directions to be appealed before the court in a timely way, as the power is wide and can affect a wide variety of persons. An appeal is genuinely for urgent matters may be expedited by the court to avoid delay. In respect of the Law Society's concerns regarding Amendments 38 and 42, in what they require or a business that has been wound down, perhaps due to a solicitor for retiring, for example, I do not consider that the duties that flow from that would be unreasonable. The right for the client's accounts to vest in the Law Society would only apply in relation to a practitioner who has been disqualified, so it would not create undue requirements. The other duties in Amendments 42 are to prepare interim accounts, which in particular detail all sums held on behalf of the client, and to send a copy of the accounts to the Law Society. And in the case of the orderly winding down of a business, this would be straightforward, to notify its clients of its intention to cease to practice and to notify its clients of the powers that the Law Society has to safeguard clients, and finally to satisfy the Law Society that it has complied with the requirements, as I've mentioned, to inform them. I'd ask members to support these amendments.
Thank you, Minister. The question is that Amendment 31 be agreed to. Are we all agreed? Yes. Parliament is agreed. I call Amendments 32, 33, 34, 35, 36, 37, 38, 39, 40, 41, 42, 43, 44, 45, 46, 47, 48, 49, 50, 51, 52, 53, 54, 55, 56, 57 and 58, all in the name of the Minister, and all previously debated with Amendment 31. I invite the Minister to move Amendments 32 to 58 en bloc. Minister.
Moved en bloc, Presiding Officer.
Does any member object to a single question being put on amendments 32 to 58? Yes. Can I just clarify that the amendments concerned are 34, 38 and 42?
Yep.
Thank you very much. In which case, the question is that amendment 32 be agreed to. Are we all agreed? Yes. Parliament's agreed. I call amendment 33. Don't need to call it, sorry. The question is amendment 33 be agreed to. Are we all agreed? Yes. Parliament is agreed. The question is amendment 34 be agreed to. Are we all agreed? Yes. Parliament is not agreed. There will be a division of members who cast their votes now. And the vote is now closed. Point of order, Marie McNair.
Aye, my vote wouldn't connect. I would have voted yes.
Thank you, Ms McNair. I'll make sure that vote is recorded. And the result of the vote on amendment number 34 in the name of the Minister is yes 59, no 58. The amendment is therefore agreed. I call amendment 30. The question is that amendment 35 be agreed to. Are we all agreed? Yes. That is agreed. The question is that amendment 36 be agreed to. Are we all agreed? Yes. The question is that amendment 37 be agreed to. Are we all agreed? That is agreed. The question is that amendment 38 be agreed to. Are we all agreed? Yes. Parliament's not agreed. There will be a division and members should cast their votes now. And the vote is now closed. And the result of the vote on amendment number 38 in the name of the Minister is yes 59, no 55. There were no abstentions. The amendment is therefore agreed. The question is that amendment 39 be agreed to. Are we all agreed? Yes. Parliament's agreed. The question is that amendment 40 be agreed to. Are we all agreed? Yes. Parliament is agreed. The question is amendment 41 be agreed to. Are we all agreed? Yes. Parliament is agreed. The question is that Amendment 42 be agreed to. Are we all agreed? Parliament's not agreed. There will be a division and members should cast their votes now. And the vote is closed. Okay, the result of the vote on amendment number 42 in the name of the Minister is yes 59, no 59. There were no abstentions. The vote is therefore tied. As is usual when Parliament has not been able to reach a decision, I'm obliged to exercise a casting vote. I will not make the decision for the Parliament. The established convention is to vote in favour of the status quo because the Chair is required to act impartially. Therefore, I cast my vote against the amendment. The amendment is therefore not agreed to. The question is, can I check whether any member has any objection to a single question being put on amendments 43 to 58? No member objects. The question is that amendments 43 to 58 be agreed en bloc. Are we all agreed? Parliament is agreed. We move to Group 10, Review of the Act. I call Amendment 137 in the name of Tess White in a group on its own. Tess White to move and speak to Amendment 137. Ms White.
Thank you, Presiding Officer. I'd also like to thank the Minister once again for her constructive engagement on Amendment 137 following Stage 2 of the bill. Amendment 137 creates a statutory post-legislative review of the Act to begin no later than 10 years after the commencement of Sections 8, 39, 52 and 78 of the bill. It requires Scottish ministers to consult regulators of legal services, consumers of legal services and the Scottish Legal Complaints Commission as part of the review, and leaves the door open for other individuals and organisations to be consulted as well. Following concerns raised about the length of the review period at Stage 2, I've agreed with the Minister that 10 years is an appropriate length of time and that it should begin from commencement of specific sections of the bill rather than royal assent. Presiding Officer, post-legislative scrutiny is so important, but in the case of the regulatory framework for legal services, I believe it is essential. This was a point made by the Competition and Markets Authority in its Stage 3 briefing, which urged regular statutory review to assess whether it is meeting the needs of consumers. Many of the issues arising in the regulatory system have occurred because so much time has passed since the Solicitors Scotland Act 1980 was added to the statute book. The Regulation of Legal Services Bill is therefore long overdue. The Law Society has been campaigning for change for at least a decade, and given that this bill has been so heavily amended, there is a strong case too for ensuring that it is operating as expected within a fragmented legislative landscape and that it is serving the interests of consumers. Stakeholders are widely supportive of a post-legislative review, and I hope it will give all parties involved an opportunity to take stock and recommend further changes in the public interest. Regulatory issues must not get lost in the weeds for years to come, which is why I urge colleagues to support Amendment 137. I move the amendment in my name.
Thank you. I now call the Minister.
Thank you. I'm pleased to have been able to work with Tess White on her Amendment 137, which will require the Scottish Ministers to undertake a review on the principal changes to the regulation of legal services arising from the Act. I'm grateful to Ms White for taking on board my concerns, and I'm content to support Amendment 137.
Thank you. I invite Tess White to wind up. Press or withdraw Amendment 137.
Nothing further to add, Presiding Officer, other than I'm very pleased to hear that this amendment is supported on a cross-party basis. I move the amendment in my name. Thank you.
The question is that Amendment 137 be agreed to. Are we all agreed? Yes. Parliament is agreed. We move to Group 11, Interdicts. I call Amendment 59 in the name of the Minister, group with Amendment 113. Minister to move Amendment 59 and speak to both amendments in the group. Minister.
Thank you, Presiding Officer. Amendments 59 and 113 are in response to concerns that have been raised by the Faculty of Advocates. The amendments put beyond doubt that it is competent for the civil remedy of interdict to be sought with a view to preventing the carrying out of an act that is subject to criminal law penalties under the Solicitors Scotland Act 1980 and the Legal Services Scotland Act 2010. For example, an interdict could be sought to prevent a person from pretending to be a lawyer, a regulated legal services provider or a member of the Faculty of Advocates. The Government recognises that interdict could be an effective remedy in preventing the continuance of that kind of deceptive behaviour as a matter of urgency and could be a useful tool for a regulator. I ask members to support these amendments in my name, and I move amendment number 59.
Thank you, Minister. No other members have asked to speak. Is there anything you wish to add by way of wind-up, Minister? Thank you. The question is that Amendment 59 be agreed to. Are we all agreed?
Yes.
Parliament is agreed. I call Amendment 138 in the name of Paul O'Kane, already debated with Amendment 117. Paul O'Kane to move or not move?
Not moved.
That is not moved. I call Amendments 60, 61, 62, 63, 64, 65, 66 and 67, all in the name of the Minister, all previously debated. I invite the Minister to move Amendments 60 to 67 en bloc. Minister.
Moved en bloc, Presiding Officer.
Does any member object to a single question being put on Amendments 60 to 67? No. The question is therefore that Amendments 60 to 67 be agreed. Are we all agreed? Parliament is agreed. We move to Group 12, Complaint Solicitors Scotland Act 1980. I call amendments 68 in the name of the Minister, grouped with amendments as shown in the groupings. Minister to move Amendment 68 and speak to all the amendments in the group. Minister.
Thank you, Presiding Officer. Amendment 75 replaces the Scottish Minister's order-making power to increase the maximum amount that the SSDT can fine a solicitor in certain circumstances, which was inserted at stage 2 with the regulation-making power. This reflects modern practice and is consistent with other ministerial regulation-making powers provided by the bill. Amendment 82 restricts the Scottish Solicitor's Disciplinary Tribunal from publishing any information that identifies or is likely to identify any person other than the solicitor against whom the complaint was made, unless it is considered to be in the public interest to do so and that person consents. This mirrors the approach taken in relation to the disclosure of information about complaints by the Scottish Legal Complaints Commission and relevant professional organisations, and provides the SSDT with additional flexibility in relation to publishing information about cases. Presiding Officer, the bill currently makes provision allowing the SSDT to take decisions and determinations relating to previous complaints into account when deciding whether the solicitor has been guilty of unsatisfactory professional conduct. The SSDT considers that this is appropriate. Amendment 69 allows the SSDT to instead take into account decisions and determinations in respect of previous complaints when it is deciding whether the censure of a solicitor is to have effect for only a specified period, and whether to direct the solicitor to pay a fine, undertake training, or to order their practising certificate to be subject to certain conditions. Amendment 74 makes a broadly equivalent amendment in respect of the powers of SSDT on appeal. Amendments 68, 70 to 73, 76, 77, 80 and 81 make minor changes to tidy up provisions following changes made at stage 2. The bill amended the 1980 Act to enable the Law Society to appeal to the Court of Session against decisions of the SSDT to dismiss a complaint without inquiry. Amendments 78 and 79 and 107 move these provisions from Schedule 4 of the 1980 Act into a new section. Presiding Officer, there was an error in Amendment 78, which should refer to leaving out line 22 on page 149 of the bill rather than line 23. And so, with your agreement, I have lodged a manuscript, Amendment 78A, to correct this. I ask members to support the amendments in my name, and I move Amendment 68.
Thank you. And I ask the Minister if she would like to add anything in winding up.
No, thank you, Presiding Officer.
Thank you. The question is that Amendment 68 be agreed to. Are we all agreed? Yes. We are agreed. I call amendments 69, 70, 71, 72, 73, 74, 75, 76 and 77, all in the name of the Minister and all previously debated with Amendment 68. And I invite the Minister to move amendments 69 to 77 en bloc.
Moved en bloc, Presiding Officer.
Does any member object to a single question being put on amendments 69 to 77? No member objects. Therefore, the question is that amendments 69 to 77 are agreed to. Are we all agreed? Yes. We are agreed. I call amendment 78 in the name of the Minister, already debated with amendment 68. Minister to move formally.
Move formally, Presiding Officer.
Thank you. I call amendment 78A in the name of the Minister, already debated with amendment 68. Minister to move formally.
Move formally.
Thank you. The question is that amendment 78A be agreed to. Are we all agreed? Yes. The amendment is therefore agreed. Minister to press amendment 78 as amended. The Minister to press or withdraw amendment 78 as amended.
Press, Presiding Officer.
The question is that amendment 78 as amended be agreed to. Are we all agreed? Yes. We are agreed. I call amendments 79, 80, 81, 82, 83, 84, 85, 86, 87, 88 and 89, all in the name of the Minister and all previously debated, and I invite the Minister to move amendments 79 to 89 en bloc.
Moved en bloc, Presiding Officer.
Thank you. Does any member object to a single question being put on amendments 79 to 89? No member objects. Therefore, the question is that amendments 79 to 89 are agreed to. Are we all agreed? Yes. We are agreed. I call amendment 139 in the name of Paul O'Kane, already debated with amendment 116. Paul O'Kane, to move or not move?
Not moved.
Thank you. The amendment is not moved. I call amendment 140 in the name of Paul O'Kane, already debated with amendment 116. Paul O'Kane, to move or not move?
Not moved.
Thank you. The amendment is not moved. I call amendment 141 in the name of Paul O'Kane, already debated with amendment 116. Paul O'Kane, to move or not move?
Not moved.
The amendment is not moved. I call amendment 142 in the name of Tess White, already debated with amendment 130. Tess White, to move or not move?
Moved, Presiding Officer.
The question is that amendment 142 be agreed to. Are we all agreed? Yes. The amendment is therefore agreed. I call amendment 90 in the name of Paul O'Kane, already debated with amendment 5. Paul O'Kane, to move or not move?
Moved.
The question is that amendment 90 be agreed to. Are we all agreed? Yes. We are agreed. I call amendment 91 in the name of the Minister, already debated with amendment 127. Minister, to move formally.
Move formally.
Thank you. The question is that amendment 91 be agreed to. Are we all agreed? The Parliament is not agreed, therefore we'll move to a division, and members should cast their votes now. The vote is closed. I call Colin Smith for a point of order.
I would have voted no, Presiding Officer.
Thank you, Mr Smith. We'll ensure that that is recorded. I call Liz Smith for a point of order.
Thank you, Presiding Officer. I couldn't connect and I would have voted yes.
Thank you, Ms Smith. We'll ensure that is recorded. I call Claire Adamson.
Would have voted no, Presiding Officer.
Thank you, Ms Adamson. We'll ensure that's recorded. The result of the vote on amendment number 91 in the name of Siobhan Brown is yes 28, no 87. There were no abstentions. The amendment is therefore not agreed. We move to Group 13, Rolls and Registers. And I call Amendment 92 in the name of the Minister, grouped with Amendments 94, 95, 96 and 97. The Minister to move Amendment 92 and speak to all amendments in the group.
Thank you, Presiding Officer. Amendment 92 will allow the Law Society to contact a solicitor who was required to complete training before being enrolled to ask whether they plan to complete the training. And if they don't respond within 8 weeks, or if they fail to complete the training within 6 months of them entering a training contract, the Law Society may remove the solicitor from the role. Section 12D of the 1980 Solicitors Scotland Act was amended at stage 2 to give registered European lawyers the right to appeal to the Scottish Solicitors Disciplinary Tribunal where the Law Society decides not to restore the lawyer to the register. Amendment 94 ensures that the provisions applying to appeals to the SSDT include appeals under Section 12D2A. Amendments 95 and 96 correct terminologies to make it clear that the power of the SSDT or the court is to order the restoration of the foreign lawyer's name to the register rather than carry out the restoration itself. Amendment 97 will ensure that the SSDT have consistent powers to award expenses in relation to all matters they deal with, including applications for restoration rather than just complaints and appeals as currently provided for. I therefore ask members to support the amendments in my name and move Amendment 92.
Thank you. I would ask the Minister if she has anything else to add in winding up.
No, thank you, Presiding Officer.
Thank you, Minister. The question is that Amendment 92 be agreed to. Are we all agreed? Yes. We are agreed. I call Amendments 94, 95, 96, 97, 98, 99, 100, 101, 102, 103, 104, 105, 106, 107, 108, 109, 110, 111, 112, 113, 114 and 115, all in the name of the Minister and all previously debated. And I invite the Minister to move Amendments 94 to 115 en bloc.
Moved en bloc, Presiding Officer.
Thank you. Does any member object to a single question being put on Amendments 94 to 115? No member objects. Therefore, the question is that Amendments 94 to 115 are agreed to. Are we all agreed? We are agreed. And that ends Stage 3, consideration of amendments. And as members will be aware, I'm required under standing orders to decide whether or not, in my view, any provision of a bill relates to protected subject matter. That is, whether it modifies the electoral system and franchise for Scottish parliamentary elections. In the case of this bill, it's my view that no provision of the Regulation of Legal Services Scotland Bill relates to a protected subject matter. Therefore, the bill does not require a supermajority to be passed at Stage 3. The next item of business is a debate on motion 17584 in the name of Siobhan Brown on Regulation of Legal Services Scotland Bill at Stage 3. I'd be grateful if members who wish to speak in this debate were to press their request to speak buttons. And I call on the Minister to speak to and move the motion.
Thank you, Presiding Officer. I am pleased that we have completed Stage 3 of the Regulation of Legal Services Scotland Bill with so much consensus on the final amendments to this bill, just as we did at Stage 2. The journey of this bill from its introduction to this final stage has been a rigorous and collaborative process involving extensive consultation and discussion. Therefore, I really would like to start by acknowledging the contributions of all stakeholders, particularly the legal professionals, the regulatory bodies, consumer representatives and members of the public who have shared their insights and their views. I want to thank them for their input, which has been invaluable in shaping this bill and ensuring that it reflects the interests of all of those who interact with the legal system. I'd also like to thank the members and the clerks of the Equalities, Human Rights and Civil Justice Committee for their scrutiny and engagement with me throughout the passage of this bill. And of course, definitely not least, I want to express my deepest gratitude to the Bill team, who predate my responsibility for the bill and have been a huge support throughout and have worked tirelessly on this for 2 years now. Presiding Officer, there is no doubt that the Regulation of Legal Services Scotland Bill is a technical piece of legislation that may seem dry to many. However, it has provided Parliament with a major opportunity to modernise and improve the way we regulate legal services in Scotland. The bill will enhance the standards, accessibility and transparency of the legal profession, making it better equipped to serve the people of Scotland in an ever-evolving legal landscape. At its core, the Regulation of Legal Services Bill seeks to deliver a framework that ensures Scotland's legal services are accessible, accountable and of the highest quality. This, of course.
Test White.
Thank you. Minister, there is a huge concern that consumers have been forgotten with this bill. What's your view of that? Thank you, Presiding Officer.
Minister.
No, I thank Tess White. I know Tess White's only come onto the committee just recently. Through the passage of this bill, it has been incredibly difficult to find a balance between the legal profession and the consumer side of it. And from day one, where I think it was suggested before my time that there be an independent regulator, that we decided not to do that. So we have engaged constructively with the legal profession and, as you know, with some of the amendments today to strengthen the consumer side. So I'm not going to say it's been easy. It's been a difficult bill to get through to find that balance, but I'm hoping today as we move forward that we've achieved that. This framework aims to balance the interests of stakeholders who, while having different views, all support this bill, ensuring that Scotland's legal sector remains trusted, transparent and effective in meeting the needs of those it serves. Presiding Officer, let me briefly remind members of the key provisions of this bill. It will provide a more consumer-focused approach by introducing a more flexible and consumer-focused regulatory structure that ensures individuals seeking legal services receive high standards of service and clarity on their redress options. For far too long, consumers of legal services have struggled to understand the complexities of the complaint system. The bill aims to remedy that by establishing clearer processes for consumers to seek redress and hold legal providers accountable. The bill also strengthens the consumer's voice by providing the consumer panel with a robust footing and a wider remit. The bill will also ensure improved oversight and accountability. The Lord President, as the ultimate regulator of Scotland's legal sector, is empowered by the bill to oversee and to improve the functions of legal services. For example, I lodged amendments at stage 2 which would transfer the ability to review a regulator's performance to the Lord President, and I've also introduced amendments which would require the Lord President's consent to be gained before any changes may be made to the regulatory category of a regulator. And finally, the bill will increase access to justice, as it will introduce provisions to widen access to legal services. It will enable innovative service delivery models, including alternative business structures, and this change will help ensure that legal services are available in a way that meets the needs of a modern, diverse society. The bill also removes restrictions on third sector bodies, allowing them to employ solicitors and represent some of the most vulnerable in our society. Presiding Officer, let me also reflect on the broader context within this legislation which has emerged. Scotland's legal sector plays an integral role in maintaining the rule of law and upholding justice. From individuals seeking advice in family law matters to businesses navigating complex commercial disputes, the demand for accessible, efficient and accountable legal services is growing. However, as we know, the landscape of legal services has changed dramatically over the past decade, and this change has accelerated in recent years. The rise of technology, the increase of diverse legal needs and the challenges faced by consumers have highlighted the need for reform. The bill is, therefore, a direct response to those challenges, a recognition that, while our legal services sector is one of the best in the world, it is not without its areas for improvement. Throughout the consultation process, many views were expressed on a single independent regulator. We have taken great care in ensuring that the regulatory framework provided by this bill is proportionate, balanced and sensitive to the autonomy of the legal profession, while also ensuring that the public interest remains at the heart of the regulatory process. In conclusion, Presiding Officer, this bill is a vital piece of legislation that has the potential to reshape the legal services landscape in Scotland, which I'm sure we can all welcome. Ultimately, this bill is about improving the everyday experience for people who need legal help and ensuring that legal services are delivered in a way that is fair, equitable and accessible for all. It is about empowering both consumer and professionals to build a stronger, more resilient legal system, one that reflects the values of our society and meets the expectations of our citizens. Presiding Officer, I am confident that the Regulation of Legal Services Scotland Bill can deliver a robust regulatory framework that serves both the interests of the legal profession and the people of Scotland, and I urge all members to support it. Thank you.
Thank you. And I now call on Tess White.
Presiding Officer, I want to thank all those individuals and organisations who have supported and contributed to the parliamentary passage of the Regulation of Legal Services Bill. And my thanks to the Minister as well, who engaged constructively with MSPs ahead of Stage 3. I appreciate that for many stakeholders, this bill is long overdue, and I hope that my amendment securing a review of the Act will reduce the timescales for change in the future. Presiding Officer, it's clear the current system, which covers entry to the profession, professional practice complaints and financial compliance, isn't fit for purpose. Much of the relevant legislation is more than 40 years old, but the legal services market is constantly evolving. The corresponding regulatory regime is clunky and inflexible. And as the Minister says, I am on the Equalities Human Rights Committee, and we've been hearing huge issues with access to justice. The whole system is frustrating for regulatory bodies, but it's often the consumer who bears the brunt of the system's failings. And we've heard in our committee that sometimes consumers are trying 100 solicitors to find a solicitor to act on their behalf, and it's crying out for modernisation. And that's why the Scottish Conservatives believe that the Regulation of Legal Services Bill is truly a missed opportunity, and why we will be voting against the bill at decision time. In the brief time I have, Presiding Officer, I want to explain our reasoning carefully, because I understand there are strong feelings throughout the legal profession about this subject. It is, however, vitally important that the consumer's voice is heard during this process as well. And there are two key issues. The first is that the bill fails to consolidate the existing legislative landscape into a single act, which the Law Society has called for to simplify the fragmented regulatory landscape. At Stage 2, the bill was the most heavily amended bill in the Scottish Parliament's lifetime. Will the member take the intervention? Yes, of course.
Minister.
I thank the member for taking the intervention. Would the member appreciate the history of this bill and how it's been going on since, I think, 2010? So if this bill doesn't pass today, we're back to scratch and there'll be no reform in the legal profession.
Tess White.
Thank you, Presiding. The Minister asked that. When this bill first started, there was an unacceptable situation that the legal profession reported directly to Scottish ministers, which was absolutely absurd and threatened the independence of the judiciary. So this bill, as we're debating it today and we're voting on it today, is not the bill that first started out. So, in fact, the Scottish Legal Complaints Commission's Consumer Panel is clear that the current regulatory landscape will be made even more complex and difficult to understand by this bill. Presiding Officer, we had an opportunity to overhaul that landscape, but the bill simply tinkers around the edges of a Byzantine system. And secondly, there has been considerable debate about who regulates the legal profession. The Robertson Review concluded that there should be a single independent regulator and a single streamlined complaints process. And I note that Consumer Scotland, in its Stage 3 briefing on the bill, has again echoed the call. However, the regulators... Yes, certainly.
Paul O'Kane.
Tess White for taking the intervention, and she spoke about the challenges that existed within the bill, particularly in terms of the independence of the judiciary. But she seems to be making the point that I'm not sure whether she is indeed supportive of an independent regulator or not. So it would be useful if she could clarify that point. But does she recognise what Faculty of Advocates said in their evidence committee, that they consider that to be a hare that was shot long ago?
Tess White.
We are fully supportive of an independent regulator. And I go back, the regulators and the judiciary were fundamentally opposed to the approach of a single regulator, independent regulator, but we believe that it is very, very important, and that part of the Robertson Review should have been followed through. The Scottish Government, in its eternal wisdom, settled on a so-called workaround in the bill which satisfied no one. It created sweeping new ministerial powers to intervene directly in the regulation of legal services, prompting widespread condemnation from the legal profession and beyond for the government's assault on the rule of law. It was bad lawmaking. Minister first.
Minister. Thank you. I think, Ms White, I'm just slightly confused by your contribution, because you're saying that the Scottish Conservatives would fully support an independent regulator, and then you're talking about the legal profession. Do you appreciate that the legal profession was 100% against the independent regulator? There's one side or the other. You can't sit on the fence on both sides.
Tess White.
I'm saying that when this bill started, Minister, the Scottish Government wanted the judiciary to report directly to ministers, which was absolutely absurd. And where we've reached right now is a tinkering around the edges in terms of increased complexity, increased cost, and the consumers is basically not taken into consideration fully. May I take Mr O'Kane's?
Okay.
I'm very grateful to Tess White for taking an intervention. Just on the theme that has been alighted at here, the concern of the judiciary was their independence and maintaining their independence in the processing of complaints. I wonder, does she envisage that an independent regulator would be answerable to the government or to the Lord President of the Court of Session?
Tess White.
The independent regulator should have report directly to the Lord President, definitely not the Scottish Government. So it is to, I will go back, it is to the Minister's credit that these powers were removed at stage 2, follows calls from the legal sector and the Scottish Conservatives. Our overriding concern at stage 3, Presiding Officer, is that the bill fails to decouple the complex complaints process from the system of self-regulation by the professional bodies. This was the recommendation of the Robertson Review, as well as the Equalities, Human Rights and Civil Justice Committee at stage 1. And I note comments from the SLCC's consumer panel, and I quote, so this is the SLCC, "We are concerned that most of the attention and concessions in the debate so far have been given to the views of the legal profession, while there has been limited engagement with the views of the consumers or consumer groups. The reality is that for consumers of legal services, it's not always clear where self-regulation ends and self-interest takes over." And I think the view is for the consumers that it feels like a David against Goliath. The complaints process is overly complex, impossible to navigate and glacially slow. I lodged probing amendments at stage 2 that use the existing infrastructure of the Scottish Legal Complaints Commission to investigate all conduct and service complaints. And finally, a key point is that it merely tinkers with the status quo. The changes don't go far enough, which is why we will vote against the bill later today. Thank you.
Thank you, Ms White. I now call on Paul O'Kane.
I'm very grateful, Presiding Officer, and pleased to speak in this debate on behalf of Scottish Labour and confirm that we will be supporting the passage of the bill at decision time this evening. And as we've heard already in contributions, this has been a long process for all involved, not merely this afternoon, although I appreciate colleagues may have felt that it felt like 2 years this afternoon, but in fact it was only 2 hours. But we have been at this bill for 2 years now. And for some stakeholders who have been calling for reform of the regulatory systems, I think it has been over a decade indeed since they began that work. And on that point, I will begin by thanking all of the organisations and individuals who have been involved in engaging on this bill, not least the Law Society, the Faculty of Advocates, the Scottish Legal Complaints Commission and many others, including people who have had experience of complaints against solicitors in Scotland. And their time and efforts, I think, have moved this bill into what I think is certainly a much better place than where it started. It would be, of course, remiss of me not to reflect on why the bill has taken so long to come to its conclusion. The bill, when introduced, as we've heard already, was indeed controversial, with the Scottish Government attempting to take control of regulation of legal services within ministerial powers. And such was the such was the significance of the threat to the independence of the judiciary and the legal profession, which is a fundamental tenet, as we all know, of a well-functioning democracy, that the senior judiciary were left in the unprecedented position of speaking out on the proposals. Indeed, I think it may be the first time in the history of this Parliament that the senior senators of the College of Justice came to give evidence on a piece of legislation that directly related to their functions and the function of legal services in Scotland. That a policy could be formed and the bill introduced that so fundamentally threatened that independence of the profession when there were no calls or recommendations indeed for such a position to be taken is still quite baffling, I'm sure, to many both in this chamber and out with. And of course, I would want to recognise that the Minister listened to that depth and breadth of concern on those proposals and brought significant amendments at stage 2 to reverse the position. But I do think there remains serious learning to be done by the Government, in my view, about how we got into the position in the first place. I would like to take this opportunity, though, to pay tribute to the Minister. The Minister, of course, came into office partway through the bill and inherited the bill in the condition it was. And she has sought, I think, to try and listen and engage, and has been constructive and cooperative through the different stages of the bill, certainly with me. And I am genuinely appreciative of her time and her engagement, and the engagement indeed of her officials and the wider bill team. I do continue to have some concerns, however, over the process we've just completed in terms of our Stage 3 considerations. The fact that an issue as significant as the status of registered foreign lawyers and multinational practices has been left to the very final day of the bill to be resolved is quite concerning and shocking, I think. We are talking about the ability of some of the biggest law firms in the UK to operate in Scotland. And as I said in my remarks on the amendments, we are talking about thousands of jobs and tens of thousands of clients. And these are issues which the Law Society and others have been highlighting for the 2 years since the bill was lodged. And it's my understanding that the regulator and body, as the regulator and body responsible for administering this legislation, there had not been detailed discussions on the matter preceding the correspondence that I referred to that was issued last night. However, ultimately, I believe over the course of stages 2 and 3, the bill has been brought to a better place, where it will provide tangible improvements to the legal system and legal services and much-needed additional protections to consumers and the public. I am disappointed that the Conservatives won't join in supporting the bill this evening, although I appreciate they are speaking in terms of their concerns about what it means for consumers. I would point out to Tess White and others that an independent regulator is not being widely called for by people in the process, particularly the Faculty of Advocates who I referred to, but also the Law Society and others. And if an independent regulator was answerable to the Lord President, I don't think that it would actually be an independent regulator. So I think there is a challenge in terms of the position which the Conservatives have arrived at, because I believe their previous position was to support the bill, or certainly the tenets of the bill, and not support an independent regulator. I welcome the powers that I have worked on with the Minister that have now been included in provisions provisions in the bill. I would like to highlight to her, however, that Amendment 42 passing and not the two subsequent previous amendments may cause perhaps some challenges in terms of the legislation, so it would be useful if she would return to Parliament, or certainly maybe in her summing up, clarify how she intends to take that forward, given that that will be a challenge in terms of the statute book. I think perhaps the post-legislative scrutiny would be a helpful vehicle in which we can seek to use those, deal with those issues. And of course, we need to understand what issues will remain in that space, and I would hope that she would use the post-legislative scrutiny to be able to do that. I will bring my remarks to a close, Presiding Officer. I do think that this bill will provide major and overdue regulatory changes for the benefit of consumers and practitioners alike. It will simplify a system that is too complex. It will make proactive a system that is currently too reactive. And consequently, as I have said, we will support the bill as amended this evening. Thank you.
Thank you, Mr O'Kane. I now call on Maggie Chapman.
Thank you, Presiding Officer. On behalf of the Scottish Greens, I welcome this bill and I thank all who helped bring it, at last, to this afternoon's Stage 3. I thank my committee colleagues and clerks, all those who gave evidence, provided briefings and shared helpful conversations. This hasn't always been an easy bill to navigate, but the progress that has been made and the cooperation achieved between stakeholders, government and opposition represent a source of encouragement for the future. This bill is in many ways a compromise, falling short of the radical reform called for by Esther Robertson's report. But it is nonetheless valuable and necessary, both for legal professionals themselves and for those whose interests we, as Scottish Greens, are most concerned about, the people without wealth, power or privilege, for whom good legal services are too often out of reach. For people typically need those legal services at some of the most stressful times in their lives, when they are moving home, setting up a business, dealing with bereavement, negotiating separation or divorce, following accidents, work difficulties or involvement with the criminal justice system. Legal professionals who are skilled and sensitive, conscientious and good at communicating can make such a huge difference to people's lives, lifting burdens, solving problems and providing real support and representation when it is most needed. But of course, the converse is also the case at times, where legal professionals are slow or careless, incompetent, extortionate or absent. Then transactions become problems, problems become crises, and crises become catastrophes. And if, in addition, the system that is supposed to address complaints and redress wrongs doesn't work efficiently, then those difficulties are multiplied. If it's slow, complex and mysterious, if it uses language that is alienating, even insulting, if it doesn't seem to listen, then the legacy of legal experience can be bitter indeed. This bill sets out to reform and improve those systems, enabling them not only to intervene swiftly and fairly when things have already gone wrong, but to act proactively, preventing the spread of bad practice and bad experience. What people want so very much and so very often is to know that the same thing won't happen to someone else. Access not just to law, but to justice is a key foundation of what we as Greens believe in. That includes access to good legal services and to redress when they are not received. But it also includes dimensions of justice unaddressed by this bill, but of urgent importance. One is access to legal services at all. We know that for many people across Scotland, legal advice and representation on matters of the utmost gravity, their homes, their livelihoods, their children, their safety and their liberty, simply aren't available, either because of cost barriers or geographical distance. Legal aid reform is long, long overdue. Another is access to appropriate courts and appropriate remedies. An environmental court with specialist expertise and a problem-solving approach would save resources of all kinds, time and money, as well as biodiversity, precious green space and the well-being of our communities. The Human Rights Bill that we campaign so passionately for would have opened up a route to remedy for violations of fundamental human rights, of dignity, equality and respect. At a time when those rights for disabled people, transgender people, people seeking asylum and home are under unprecedented threat, Access to justice matters. It matters desperately. So I welcome this bill, and we will be voting for it at decision time this evening. I'm grateful to all who have got us here, but we still have so much work to do. I urge us all to remember, as we vote on this bill this evening, we are not only talking about law, we are talking about justice. Thank you.
Thank you, Ms Chapman. I now call on Liam MacArthur.
Thank you, Presiding Officer. I noted the concerns being expressed by Paul O'Kane earlier about the amount of time we've been considering this bill and debating it this afternoon. I would just observe this is but a blink in the eye compared to where we found ourselves at this same time last week. But I too join others in thanking the committee but also the Minister for their work on this piece of legislation. I took part in the Stage 1 debate, and it's fair to say we've come a fair way since then. The bill introduces many welcome reforms that are long overdue. As the Law Society, I think, fairly highlights, this legislation will act to modernise and reform regulatory systems, some of which have been in place for 4 decades or more. I was a member of the Justice Committee at the time that Esther Robertson published her review, and it highlighted very clearly the lack of transparency, clarity and simplicity within the current landscape of legal services regulation. And although this bill stops short of one of the review's key recommendations for an entirely independent regulatory body, it does, I think, nonetheless go some way to improving the accessibility and reliability of legal services, and point to the issue that Maggie Chapman was raising in terms of that access to justice. The task faced by the Minister and the committee to find an appropriate compromise that doesn't diminish the principle of an independent and vigorous system of regulation, but ensures that we don't tie the hands of regulators and practitioners in maintaining a system that is workable and flexible was no small task. One area that clearly prompted particular opposition and concern at the time was the inclusion of what felt like arbitrary and overreaching ministerial intervention within our legal services. And I think it was regrettable that pretty fundamental tenet of the legislation was left to the amendment stage at stage 2. I think I would acknowledge the point that Paul O'Kane, I think, very reasonably made that this was a situation that the Minister inherited and I think has done a power of good work in seeking to address with the cooperation of the committee. So the bill, as I say, that we are dealing with today is a very changed beast from that confronted us at stage 1. I commend the committee for their efforts. It's clearly been a collaborative endeavour. I think the amendments that Tess White has successfully progressed today in relation to the 10-year review will serve us well. Likewise, the amendments to toughen up the approach to unregulated legal services are a valuable addition to the bill. I think the steps taken on the basis of Paul O'Kane's amendments to improve transparency are also very welcome and I know have been welcomed by the Law Society and going some way to restoring public confidence and a sense of accountability within those systems. We have, as I think the Minister in an intervention earlier suggested, this has been a process embarked upon back in around 2010. There has been considerable effort through the amending phases to address concerns. It has, though, and I think this is an observation I made at stage 1, it felt like it was rather rushed in terms of its introduction, which is surprising given how long these issues have been under consideration. But the work taken forward at stage 2 and again at stage 3 today I think have left us in a much better place. This legislation will take important steps to improve a system that has for too long failed to meet the needs of consumers or even many working in the sector, a system that was outdated, overly complex and, as we've heard, repeatedly failed the public, many of whom found themselves in vulnerable positions when seeking recourse in the face of misconduct or wrongdoing. I think the bill in front of us today better reflects the needs of a diverse and rapidly evolving legal services sector and builds much needed transparency, accountability and protections into a system that must work to safeguard the interests of consumers and protections. And for that reason, Scottish Liberal Democrats will be voting in favour of decision time shortly. Thank you.
Thank you, Mr MacArthur. And I call on the Minister to wind up. A very generous 4 minutes, Minister.
Thank you very much, Presiding Officer. I want to take a moment to reflect on the importance of the regulation of legal services Scotland Bill and the hard work that's gone into bringing it to this point. That includes engagement with members across the chamber, and I want to thank everybody for all their engagement and many who have spoken today as well. The bill is a significant step forward in ensuring that Scotland's legal services are accessible, accountable and of the highest quality. The changes that we are debating today are not just about regulatory frameworks or the legal process, but about the people of Scotland, the people who rely on legal services and the professionals who serve them. We are crafting a legal services system that is robust and also flexible, transparent and equipped to meet the needs of a modern society. Presiding Officer, I am particularly pleased that we've been able to introduce changes that will enhance transparency for consumers, enhance access to justice and create a framework that fosters both public confidence and professional respect. The bill empowers the Lord President, bringing much-needed oversight, while also ensuring that the legal profession in Scotland continues to uphold the high standards that it is known for. I also want to acknowledge that this bill is not the end of the journey, but rather the beginning of an ongoing process of refinement and improvement. We have created a foundation for a regulatory framework that can adapt to future changes, and it will be vital for us to remain open to further improvement as the legal landscape evolves, including during the implementation of the bill by secondary legislation. Presiding Officer, I am confident that with this bill we are setting Scotland's legal services on a path to greater fairness, accessibility and accountability for years to come. Over the course of today's debate, we've heard a range of important contributions from members on this critical piece of legislation, and I'd just like to take a moment to reflect on some of the contributions. I'd firstly like to thank Scottish Labour, the Scottish Greens and the Scottish Lib Dems for all your engagement and for backing the bill today. I have to say I am so really disappointed in the Scottish Conservatives for not supporting the bill at stage 3, and I'm also so confused by your stance. I think the consumer side would be extremely concerned on Tess White stating that the independent regulator should be regulated by the head of the judiciary, the Lord President. For clarity, Esther Robertson sought accountability out with the judiciary. So it's disappointing that the Scottish Conservatives don't appear to have a clear understanding of the history of all the work that's gone into the bill, nor the asks of the consumers or the legal profession, and I find it a very sad reflection. Just a few other contributions. The League Committee recognised the differing views on the legal profession and consumer groups on the question of regulatory reform, but also the fact that there is broad support for improvements introduced by this bill. As members will note, I have sought to work in a collaborative way with members and stakeholders to consider their concerns and their concessions where I consider that it is sensible, and I believe that the bill balances and delivers key priorities to stakeholders. Members today have the opportunity to vote on a bill that will reshape how legal services are delivered and experienced for professionals and consumers alike. Our goal is clear: a legal services system that works for everyone. I therefore ask members to support the motion in my name and pass the Regulation of Legal Services Scotland Bill. I'll bring in Paul O'Kane.
I am very grateful, and I'm aware that the Minister was in her peroration there, but I am keen just to try and get some clarity on the issue of those amendments that we debated, particularly around safeguarding. She'll know the significant issue I raised that the Law Society had pointed to in terms of issues like conveyancing and there not being sufficiency in terms of being able to finalise a house sale. Obviously, Amendments 34 and 38 were rejected by the Parliament, but Amendment 42 was passed by the Parliament. It would be useful if she could put on the record her intention of how to deal with that, because there was a consequential lead-on from those amendments.
Kane for his question and for reminding me to get to that point, because I might have missed it. So, yes, the consequences of Amendment 42 not being agreed to, there is no right of appeal to Court of Session against direction given by the Law Society under Section 46(b)(4) of the Solicitors Scotland Act by sole solicitors or a sole solicitor business, and contrast that with the right of appeal for a legal business regarding the direction under Section 46(a)(4) of the 1980 Act. Obviously, this has just happened. I'll have to take time to reflect, and I will get back to members on that specific point with that amendment. And with that, Presiding Officer, I ask members to support the motion in my name and pass the Regulation of Legal Services Scotland Bill. Thank you.
Thank you, Minister. That concludes the debate on Regulation of Legal Services Scotland Bill at stage 3. It's now time to move on to the next item of business, and I'm minded to accept a motion without notice under Rule 11.2.4 of Standing Orders that decision time be brought forward to now, and I invite the Minister for Parliamentary Business to move the motion.
Move, Presiding Officer.
Thank you, Minister. And the question is that decision time be brought forward to now. Are we all agreed? Yes. We are agreed.